Please, Your Lordship, I beg to mention item number 15 and 16. Conducting counsel is indisposed, Your Lordship. Can you have this matter after 2 weeks?
These are all matters.
Yes, Your Lordship.
If your colleague is indisposed, you could have done it.
Yes, Lordship. But
You see, you have ample time, ample opportunity to prepare and come.
it's a lengthy matter, Your Lordship.
On pre-made by the Senate Council, Mr. seeking accommodation on ground of personal difficulty of the learned conducting counsel. Matters adjourned. This is the same after 2 weeks.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 14. Your Lordship, here the draft rules have the amended draft rules have been drafted, Your Lordship, and the same has been placed before the committee. So, Your Lordship, we pray for somewhat time.
That was the same statement you made.
Yes, Your Lordship. Moreover,
on
Your
numerous
Lordship, here
occasions.
the petitioner number 1 has also been promoted. So the petitioner was supposed to take instructions whether the petitioner number 1 wants to continue with the case or not.
Some more time may be given, Your Lordship.
On pre-made by the parties, this is matter to 3 weeks.
Obliged, Your Lordship.
Obliged, Your Lordship.
Lordship, this is that matter pertaining to transit anticipatory bail, Lordship. If Lordship allows me, I start, Lordship.
All the respondents have been, notices have been issued to all.
Lordship, 2, 3, Lordship, affidavit being on record of service has been filed already, Lordship, and on the last occasion, only respondent number 2, who is a formal party, Lordship, they have not received, Lordship. Otherwise, all the main respondents, they have received, Lordship.
I think that is exactly the point. I think that is the issue that we are supposed to
Correct, my lord.
discuss. Whether we can proceed with the
Yes, my lord.
without the respondent number 2.
Yes.
Because, my lord, respondent number 3 is the superintendent of police, and respondent number 4 is the superintendent of police of Darjeeling and Kalimpong. So they have been received, my lord. They have received, but they have till date not appeared before this honorable court.
Yes, I think this court has observed
Yes,
on the
Lordship.
last
On the last occasion.
that you see the respondent number 2
Yes, Lordship.
is the state of West Bengal.
Lordship.
Why would notice issued upon them not been received,
Lordship.
rather not been acknowledged? And how can you make a mistake as far as the address is concerned?
Lordship.
I don't think there should be a mistake.
Lordship.
So why is why would the notice return unserved, or address not known, or for whatever reason we don't know? That would be a,
And in that event,
and the fact is that I don't know whether we can proceed ex parte against any respondent for the matter who notice of which have not been affected.
My lord, the term transit bail, my lord, itself signifies, my lord, it is for a short duration of time to felicitate the petitioner to approach the court of jurisdiction, my lord. Now, my lord, this has been extending, my lord, since last 5 months, my lord. Now there are a number of citations, my lord, where, my lord, even without impleading the, my lord, the police station having the jurisdiction over the matter, my lord, transit bail has been allowed, my lord. I have that, my lord, and that is that, my lord. So therefore, my lord, this matter can be disposed. In fact, this is a case where, my lord, interim has already been granted, my lord. So, my lord, 5 months. What is stopping the petitioner to approach the court of jurisdiction, my lord?
Yes, I think that was the query.
Exactly.
That was a query, Lordship, which fell from.
It cannot go on like this, my lord.
Also, Lordship, because of the pendency of this application, Lordship, we have not approached the
Why?
Lordship.
When there's, as Mr. Guru had said,
Lordship.
when there's an interim in place, you could have approached the any point of time, even on the strength of the.
My lord, yes. Transit bail itself is an interim bail,
That,
my lord.
yes, exactly. That would have served the purpose.
But Lordship, as far as this petition is concerned, because of the pendency of this instant application, Lordship, we didn't prefer any other application at the jurisdiction at West Bengal, Lordship.
My lord, my friend hasn't understood, my lord. The term transit bail itself is an interim bail, my lord.
Exactly.
To that effect, Lordship.
Yes, it's interim because you see, you still have to go to the particular place and seek regular bail.
My lord.
This court, you see, if you have not subjected yourself to the jurisdiction of this court, as far as the merits of the case is concerned, then what can we do?
My lord, the earlier order may be modified to the extent, my lord, that a limited time may be, my lord, specified, and within which approach the, my lord. The law allows that, my lord.
Heard learned counsel of the parties. This is the application for grant of extraterritorial anticipatory bail, oblique transitory anticipatory bail, oblique limited anticipatory bail. As far as the petitioner herein is concerned, who is said to be involved in cases outside the jurisdiction of this court, namely
West Bengal, Lordship.
in the state of West Bengal. The petitioner, being a resident of this state, has approached this court with prayer for grant of such kind of bill to allow him to have a safe passage to the place of occurrence, or rather to the jurisdictional police station or court, where he can proceed in accordance with law as far as proceed in accordance with the law. This court, at the outset, on prayer made by the parties, pending issuance of notice upon the respondents herein, have granted interim bail. However, in course of time, it appears that some of the respondents have not yet received notice. Be that as it may, Mr. Argun Lanerji has submitted that there is no bar for this court to allow the interim bail, which in fact would amount to a transit bail as far as the prayer of the petitioner is concerned. Therefore, it is the submission of the learned G that the earlier order passed by this court granting interim bail may be modified to the extent that the same be converted into a transit bail to allow the petitioner to approach the concerned court as desired by him. Concerned jurisdiction as decided by him. Without going to the merits of this case, on this ground, the court is inclined to agree with the submission of the learned GA, and accordingly, the petitioner is hereby, the earlier order is modified, and the petitioner is hereby allowed. Petitioner is granted interim bail to allow him to proceed to the said place of destination, wherein the proceeding against him may be agitated. Accordingly, this matter is disposed of. Accordingly, this petition is disposed of as indicated here and above.
My lord, if I may, my lord, certain timeline may be given, lordship.
The petitioner is to. What timeline?
Lordship.
Within a
There is
period
a
of
serious
15 days, my lord.
30 days,
Time.
lordship. 30 days.
Time.
Continue to stay here.
My lord.
30 days, lordship.
It's Bengal, my lord.
Lordship, Bengal, but there is a serious threat to my life, lordship, as it can be seen, lordship.
The petitioner is. It is made clear that during the pendency of this transit bill, the petitioner is not to be arrested or confined to custody. He is, however, directed to secure regular bail if so desired with a period of 20 days from today.
Deeply obliged.
Should be obliged.
On daily list, item number 1.
The lawsuit.
Yes. Yes, sir.
This is the instruction.
It's not fully complied, Your Lordship.
Position remains the same.
No illusion.
Only a few has been increased from the last instructions that we have received.
Anyway, something is better than nothing.
Something. We can always keep the contempt also pending, Your Lordship.
Out of this order, illusion, this contempt may be even closed.
30 plus it seems.
38 have been.
Number of bills cleared.
From the last time, that means 38. No. Number of bills received 165.
165 not completed, and that 27 not yet received.
But why are you taking so long?
Give me one copy.
Yeah,
38 only has been passed as per this instructions.
NPS this is going to be prepared due to technical error in the software, so this was not possible.
And it
Otherwise,
seems, Your Lordship, some dealing officer was on leave also, it seems.
Mr. Archival Data CGC has produced copy of an order dated 4/11/2024, wherein the latest status report of the proceedings before the concerned authority have been indicated, to the extent that out of 192 petitioners, the bills of 165 of them have been received, and 38 of such bills have been passed, with 127 bills under process and 27 number of bills not yet received from the unit concerned. The London CGC has also submitted that the delay in the proceeding is because of certain technical error in the software, and as such it is prayed that some more time may be allowed for the entire process to be completed. On consideration of the submission made, the respondent is directed to complete the process within the next date fixed. This is matter after 1 month.
Obliged.
With 1 month.
Item 1 and 4.
With the status report to be filed by the respondent. Item
1 and 4.
same order.
Obliged.
Item number 2.
Lordship, in item number 2, we have filed appeal, Lordship. Number 2, 6 to 11, Lordship. Will be listed, I think, next week, Lordship, because the bench will be listed in the warning list of listed. All the matters will be listed next week. If this matter can come up after 2 weeks.
Mr.
My Lord, I may pray. She has filed an appeal, not yet listed, my Lord. However, the matter pending before District Council, parties have submitted a written argument also, and is expected to pass the final order.
They have filed. We have not filed a written argument. We have filed an application to dispose the representation as per law, as per this court has directed to dispose the representation as per law and not to prejudice the parties. We have filed an application that before deciding whether the STF committee has the power to review, before we're taking up that matter, Lordship. Without disposing our representation, he has passed that order on 8.
What order?
That the order which has been placed at the last.
Not on the last occasion, I had placed the order passed by the council, dated. Your Lordship will see the order dated 1710.
Oh yes. This order dated 8/10.
Yes, we have passed an order. In fact, the grievances of the petitioner has been redressed.
Or he has been prejudiced, as Lordship, since 2023.
That is a separate cause of action altogether.
No, Lordship, this is because Your Lordship has allowed it in this petition and then in the interim to dispose of the representation and to as per law and not to prejudice the parties. Now, without disposing a representation.
Mr. Kriam, I think if I recall correctly,
yes,
the direction of this court is irrespective of how the representation was disposed of.
Yes, sir.
Whether it is still pending or finally disposed,
yes,
it would still be subject to the proceedings before this court.
Yes, sir.
Of course, that is provided.
Because Your Lordship has stated clear that it should be disposed as per law without prejudicing any of the parties. It's there in the order, Lordship.
Yes, could be.
But now by passing that order on the...
Now, you would be aggrieved by that order.
Yes.
No, Your Lordship, because Your Lordship has said that not to prejudice. Now they have prejudice because since 2023, 2023, we have been recognized as a full-fledged village. Now the passing of that order, again we have been reduced into a locality. Lordship. Now all in the 2 years development have been done. Then as per the block development officer, we have been recognized as village. Even the chief has been recognized as village. Now 2 years has passed, almost 2 years has passed. We have been, during election, everything has been done as a full-fledged village. By passing that order, again we have been reduced to locality. Now, yes, now will be a problem for us, Your Lordship.
That's a separate course of action. That's
no, Your Lordship.
There is separate
because Your Lordship has directly clearly stated in order not to prejudice.
I just pray with Lordship permission.
So how are you aggrieved by the order of the court?
Order of the court, no, Your Lordship, because Your Lordship has passed that order not to
yes.
Now they have again reduced us to.
So now, if they have done it, why do you blame the court then?
Your Lordship.
I was about to say that.
I'm not blaming the court, Your Lordship.
Because this order has been passed rightly or wrongly by the executive
No, Your Lordship, I'm not blaming the court. The court has given a clear direction not to prejudice and to dispose as per law. They are not doing, Your Lordship. Then we have, prior to that also, we have filed application stating that clearly that the court has directed to dispose the matter.
It's your right to file
Yes.
appeal. That would be disposed of on merits. That is not a.
Because my summation is that this writ petitions, all these writ petitions have become infructuous in view of the order passed on 8
Your Lordship.
on 8/10/2024.
Because we have filed an appeal,
Because the
Your Lordship.
order challenged by them before this court, that has been set aside by the executive committee. What else remain?
Yes, yes. I recall that.
Yes.
Right. But in view of that, my lord, District Council allowed parties to submit a written argument to dispose of the entire matter. So it is likely to be completed soon. Therefore, I prayed for next week Tuesday, my lord. Otherwise, the appeal filed by my friend, Lordship may recollect, on 25th July, Lordship allowed the District Council to look into the representation filed by me without prejudice to any parties. Now, all of us received the notice from District Council. We appear. Out of 6, my lord, 7 petition, 1 has preferred writ appeal. Writ appeal is not yet taken up. Thereafter, my lord, your lordship taken up the matter, saying that, my lord, my friend said no, the other connected writ petition, lordship did not pass similar order. So, with the consent of the party, lordship passed an order that 25th July order would be applicable to all the writ petitions, except that WPC 119. Pursuant to that, they agree. All of us appear before District Council. They file application about the maintainability of the representation. It is pending. Now, what happened? I received a memo of appeal last week. They are challenging the order passed by my lord on 25th July, where they agreed themselves that it will be applicable to all the writ petitions. So, all the writ petitioners now, responding the writ petition.
If that is the subject matter of the appeal, then it will be decided at that.
Right. So it subject matter is my division bench. My lordship will division bench will consider, but there is no prayer to stay the lordship proceedings. So since the representation is about to be disposed of, my lord, I pray for.
Anyway, that will give you time also to pursue the
2 weeks. It's a matter 2 weeks.
On payment by the parties. This is matter to 2 weeks.
Item number 3.
Connected matters, my lord, till 2 to 11, my lord.
2, 6 to 11.
Or
2, 6, 7, 2, 6 to 11. These are connected matters.
Item number 2, then 6 to 11.
These are same.
Fine. Same order will be passed.
Item number 3.
Please, Your Lordship. Lordship, in this matter, I am bringing some accommodation, Your Lordship. The senior counsel is leading this matter, Your Lordship. So,
what is this?
This is a transit and
transit bail only, my lord, where the FIR was filed before Maharashtra.
Any interim?
Your Lordship.
Interim is there? No.
So then an order will be passed in the same line.
Same, my lord. It should be disposed of. There is no interim.
Your Lordship, senior counsel is leading this matter, Your Lordship. So,
Senior counsel or not, you are also there.
I've instructed, Your Lordship. Your Lordship may fix it tomorrow, Your Lordship.
As far as the law is concerned, there is no senior, there is no junior.
Kindly fix it tomorrow.
Listen to all. See, because it's all a matter of record.
Your Lordship.
You are also competent enough to take up the matter. What is there?
Kindly fix it tomorrow, Your Lordship.
Bail matters more often than not should not linger.
Your Lordship.
Because it involves the liberty of a person, rightly or wrongly.
Your Lordship.
Yes, what is the facts of the case?
Lordship, Lordship, I'm praying that Lordship will fix another board, Lordship. The senior counsel is leading, Lordship.
So first you tell me, notices have been affected on all respondents?
Lordship, with regard to respondent 214, Lordship, it's returned unserved, Lordship. So we have filed affidavit of service with regard to that, Lordship. 214, the state of Maharashtra.
Any interim order pass?
There is no interim. No interim, my lord.
No interim?
No interim.
No, Lordship.
This one is affected, no? 2 to 4.
So you were saying what is the status on notices issued upon the
Lordship,
respondent?
with regard to respondent
So 1 and 2?
2 and 4, Your Lordship.
2 and 4 have
2,
received.
3, 4, Your Lordship, has been received, but none appeared.
Not What about 1?
One,
One
state,
is there.
State of Meghalaya.
Then
One
that's all.
appearing, my lord.
We'll proceed ex parte against them.
Yes, notice has already been served.
You file affidavit of service also.
Just show me the authority as far as transit bill is concerned. Do you have any citation, any rulings?
Lordship, with regard to, if Your Lordship kindly allow, Your Lordship will provide the authorities, Your Lordship, for us 1 hour, Lordship.
End of the board.
Lordship.
Item number 5.
May it please your lordship.
Yes, Mr. Paul.
May I pray if this matter can come up after a week or 2 weeks, my lord? This item number 12, my lord.
Why?
I just need someone to prepare and only now that only the state will have to defend the entire case, my lord.
See, Mr. Sengupta, you've had 10 years time to prepare, almost 10 years time to prepare. What else there?
Still, my lord,
By now you would have known each and every word by heart.
You will have to be prepared, my lord, since the other respondent has. After 2 weeks.
Doesn't matter. Yes, Mr. Paul.
Well, let's see.
On prayer made by Mr. S. Sengupta, learned additional senior GA, seeking accommodation on grounds of personal difficulty. The same not be objected to by the petitioner. Matter is adjourned. List the same after 2 weeks.
Right.
Item number 13.
So, I think the respective parties, they have filed the written argument apart from the oral submission advanced before the court. Even I also given my oral submissions advanced before the court. So far the written argument is concerned. From my side also, I am filing written argument today. I'll just say.
I represent the respondent number 1 and 2, my lord. I am also filing my written short synopsis.
Keep. I hope your written submission is long. If it is short, then I have already forgotten what you have submitted. This matter was heard, I think, a very, very long time ago.
Yes, long time and several times it was heard.
Okay, so who is appearing for the petitioner?
I'm for the petitioner, Your
You
Lordship.
have filed your.
Yes, Your Lordship.
You have filed.
You filed on the last occasion, Your Lordship.
So all the respondents have.
Yes.
filed. So matter will be reserved for.
Yes.
The learned respective counsels appearing for the learned counsels appearing for the respective respondents have submitted that the brief written argument or synopsis of the argument has been filed for this court, and accordingly this matter is now complete in all respects, for which the judgment is now reserved.
Obliged, Your Lordship.
Item number 17.
My lord, this matter relates to suspension order. He was placed under suspension in 2017. Until today, suspension order is still operating. Therefore, we challenge this before this honorable court, my lord. I just take the background of the case briefly before I will cite the judgment of the apex court. My lord, we come to page number 17, annexure 1. He is a teacher.
Yes, ma'am.
Now, this is the FIR lodged on 9 September 2020.
Yes.
Page 17, annexure 1. Date of the FIR is 9 September 2020.
Page 17. Yes.
My lord, contain paragraph 2, 3, and 4. I may not read, my lord. Now, pursuant to this FIR,
Yes.
he was placed under suspension, page number 21. Lordship, may kindly come to page number 21.
Page 21.
21, my lord. Annexure 2.
Yes.
Suspended on 15 September 2021.
Yes.
Now, thereafter, my lord, the writ petitioner, page number 27, he sought for revocation of the suspension order by taking the plea that the 3 months already expired and no review or extension order was passed. Therefore, he sought for revocation of the suspension order, relying on the judgment delivered by the Apex Court in the case of Ajay Kumar case, 4/1/2018. My lord, it was not revoked, and thereafter, page number 30, the disciplinary authority has constituted the inquiry committee. This order was passed on 2nd Feb 2018. It says, my lord, in connection with the suspension of Sri Sansaj, assistant teacher, Government Girls Higher Secondary School, Shillong, relating to the Lapan PS station, police station case number Sansaj, POCSO, read with Sansaj, the departmental inquiry is hereby constituted with the following members. So 2 members were constituted. Now, thereafter, my lord, page number, this order was issued by the director. He's a competent authority. Lord, may kindly see in the meantime, the same date, page number 32.
Yes.
This show cause was issued to the petitioner. At the bottom, I read out, my lord.
Yes.
Sri Sansaj, Joint Director of the School Education Literacy, is hereby authorized to conduct the inquiry and to submit his report to the undersigned with his findings. Your written statement stating whether you desire to be heard in person should be submitted to the aforesaid inquiry officer. In fact, though I did not challenge this, this is an illegal proceeding. Once the choice is, my lord, either disciplinary authority has the power to conduct the inquiry by himself. If he doesn't want, then he appoint inquiry officer. The moment he appoint inquiry officer, it is the duty of the inquiry officer to issue show cause notice to me. But here, my lord, differently, he is the one who formed the inquiry committee, and he is the same person is issuing show cause notice to him. But anyway, my lord, I do not challenge this legally. The issue is not relating to this. Thereafter, my lord, I have requested them to give me the opportunity to inspect the documents, page number 36, my lord. My lord, neither the inquiry officers appointed proceeded the matter, nor the disciplinary authority take over the inquiry and conduct the inquiry. Inquiry is not conducted. Thereafter, my lord, page number, my lord, 42.
Yes.
This is the order, office order. In continuation to this office order, such and such, Sri Sansaj, assistant teacher, school Shillong, the suspension is hereby allowed to draw the subsistence allowance, and such. So subsistence allowance order was passed. It is continued now. But they did not revoke the suspension order, nor review or extend it. Therefore, I filed this petition before this court. Now, the law on this is, according to me, it's very clear. I would cite the...
So what, so the proceeding have not yet started?
Not yet started. Now, only the plea taken by the department is that the POCSO proceeding is going on before the trial court. So, until unless that POCSO trial is over, petition need to be placed and remain under suspension.
But that is not a... That is not okay. You see, 2 proceedings can run parallelly.
It can be run. Therefore, I'm going to cite. Therefore, that will not prevent. That will not prevent trial of criminal matter by the criminal court did not prevent the departmental authorities to proceed with the disciplinary proceedings. Because
Okay, apart from that, tell me, what is the status of the POCSO?
my lord, POCSO trial is almost completed. Completed. Now what happened, my lord, the trial almost completed. Judgment will pronounce, my lord, party may go for appeal. Therefore, my lord, the pendency of the criminal case do not preclude the department to proceed with the disciplinary proceedings.
I think that is well settled.
Yeah, well settled. Now the issue here is my contention is that once, my lord, the suspension, a person is placed under suspension, my lord, in view of the Supreme Court order, if the department deem it fit to extend it, they can extend it during this suspension period. Once the 90 days is over, suspension order cannot be extended. That is the case I cited. Now, page number 43, this is the judgment rendered by Supreme Court. Now, I would cite this one, but now the earlier occasion, my lord, the learned JAG has cited the full bench decision, 3-judge bench decision of the Madras High Court, saying that the Supreme Court did not lay down a good law in the case of Ajay Kumar. Therefore, my lord, I will request my lord to bear with me, and I will take the factual position of the case in Ajay Kumar, as well as the issues involved in the Madras case. My lord, relying on this Ajay Kumar case, this honorable court has even passed an order revoking the suspension. My lord. Now, Lordship, kindly see page number 43. 43.
Before my friend proceed further, Your Lordship, we would like to know what is the stage of the criminal proceeding, Your Lordship, because our contention
That's what he said. It's at the stage of judgment.
In the final stage of the trial, that was the I received information. That doesn't preclude the petitioner, but they preclude the department, not precluding to me to invoke Lordship jurisdiction. That is the latest status of the trial matter.
That is just a matter of fact.
Yes, yes. Right.
But if you wish to raise any legal issue on it, then
right. My lord.
We can do so.
My lord, may kindly bear with me and read page number 43, my lord. Ajay Kumar case. My lord, this Ajay Kumar case delivered in 2015. My lord.
Excuse me. Yes.
The person was placed under suspension, and the suspension order was extended from time to time. Now, this petitioner has filed a petition before the CAT, Central Administrative Tribunal, contending that his suspension is wrong. Now, the CAT has written a finding that we will not interfere with the suspension in extension order, but the department cannot indefinitely keep him under suspension, number one. Number two, if the department wants to proceed the inquiry, that inquiry should be concluded immediately. That was the finding of the judgment of the CAT. Being aggrieved with, central government filed a writ petition before the High Court. The contention of the state government, the union is before the High Court is that CAT has absolutely taken over the role of the executives. Whether a person should be suspension should be extended or not extended, this is the prerogative of the executive, not of the court or not the CAT. So that was challenged. Now the High Court has upheld that contention. Matter reached to Supreme Court, filed by Ajay Kumar, and Lordship, this judgment was delivered. Now, since my lord, the respondent is disputing or saying that this is not a good law, therefore it is imperative on my part to take the to Lordship dropper to go through certain paragraphs, my lord, so that we will exactly know whether Supreme Court really laid down a good law or not.
You don't have the journal citation here?
Oh, my lord, since I have annexed, I did not prepare the SSC one. It must be there also, my lord. My lord, may I start from para 2? And this is very important, my lord. If my lord, this will go to hell that the law laid down in Ajay Kumar case is not a good law, my lord, that will run contrary to the order passed by this Honorable Court in other cases also. My lord, para 2, factual background, my lord. The appellant assailed his suspension, which was effected on 30/9/2011 and has been extended and continued ever since. In November 2006, he was posted as a Defense Estate Officer, Kashmir Circle, JNK. During this tenure, it was discovered that a large portion of the land owned by the Union of India and held by the Director General of Defense estates had not been noted in the revenue records as defense lands. The appellant alleged that between 2008 and 9, office notes were prepared by his staff, namely such, that approximately 4 acres of land were not defense land, but were private lands in respect of which NOCs could be issued. These NOCs were accordingly issued by the appellant. Thereafter, on such 2010, the appellant was transferred to Ampala Cantonment. However, White Letter such 2011, the appellant was asked to give his explanation for issuing the factually incorrect NOCs. In his reply, the appellant admitted his mistake, denied any malafide in issuing the NOCs, and attributed the issuance of the NOC to the notes prepared by the subordinate staff of the such. It was in this background that he received the suspension order dated such 11. Various litigation were fruitlessly initiated by the appellant in the Central Administrative Tribunal, Chandigarh Bench, as well as the Punjab and Haryana High Court, which we are not concerned. The appellant asserts that since the subject land was within the parameter wall of the Air Force Station, no physical transfer thereof has occurred. On such, the appellant's suspension was extended for the first time for a further period of 180 days. This prompted the appellant to approach the GATT, Chandigarh Bench, and during the pendency of the proceedings, the second extension order was with effect from such 2012 for another period of 180 days. The challenge to this extension did not meet with success before the GATT. Thereafter, the third extension of the appellant's suspension was ordered on such, but for a period of 90 days. It came to be followed by the fourth suspension for yet another period of 90 days with effect from 2013. It appears that the tribunal gave partial relief to the appellant in terms of its order dated such, opining that no employee can be indefinitely suspended, that disciplinary proceedings have to be concluded within a reasonable period. The GATT directed that if no charge memo was issued to the appellant before the expiry of 2013, after then prevailing period, the appellant would be reinstated in service. The GATT further ordered that if it was decided to conduct an inquiry, it had to be concluded in a time-bound manner. The appellant alleged that the suspension was not extended beyond such, but this is not correct. The respondent Union of India filed a writ petition before the Delhi High Court, contending that the tribunal had exercised power not possessed by it, inasmuch as it directed the suspension would not be extended if the charge memo was served on the appellant after the expiry of 90 days from 2013. That is the currency of the then extended suspension order. This challenge was found favor with the court in terms of the impugned judgment dated since 2013. The writ court formulated the question before it to be whether the impugned directions circumscribing the government's power to continue the suspension and also to issue a charge sheet within the time-bound manner can be sustained. It opined that the tribunal's view was nothing but a substitution of the judicial determination to that of the authority possessing the power, that is the executive government, as to the justification or rationale to continue with the suspension. The writ petition was allowed and the central government was directed to pass appropriate orders as to whether it wishes to continue with the suspension or not, having regard to the relevant factors, including the report of the CPI, if any, it might have received by now. This exercise should be completed as early as possible and within 2 weeks from today. This has led to the filing of the appeal before this court. In the hearing since 2014, it was noted that by the letter 2014, the suspension of the appellant had been continued for a period of 90 days with effect from 2014, that is the fourth extension, and that investigation had been completed. Sanction for prosecution was about to be granted within a period of 2 weeks. When the arguments were heard in great detail on 9 September 2014, by which due date neither a charge sheet nor a memorandum of charges have been served on the appellant. It had been contended by the learned counsel for the appellant that this letter, as well as the preceding one dated since such, had been backdated. We had to call for the original records, and on perusal, this contention was found by us to be without substance. The learned Additional Solicitor General has submitted that the original suspension was in contemplation of the departmental inquiry, which could not be commenced because of the directive of the CVC prohibiting its commencement if the matter was under the investigation of the CBI. Well, the sanction for prosecution was granted on such 2014. It was also submitted the charge sheet was expected to be served on the appellant before 12/9/2014, which before the expiry of the fourth extension. However, we need to underscore that the appellant has been continuously on suspension from 2011. It is necessary to record that all the relevant files were shown to us, on the perusal of which it was evident that reasons were elaborately recorded for each extension of suspension and within the currency of the then prevailing period. Therefore, the reliance of the learned senior counsel for the appellant on such is of no avail, since the salutary requirement of natural justice, that is of spelling out the reason for passing of order, has been complied with. Learned senior counsel for the appellant, however, has rightly relied on the series of judgments of this court, including O.P. Gupta and such, where this court has enunciated that the suspension of an employee is injurious to his interest and must not be continued for an unreasonable long period. That therefore an order of suspension should not be lightly passed. Other contention has been drawn to such case 1999, which is topical in that it castigates selective suspension perpetuated indefinitely in circumstances where other involved person had not been subjected to any inquiry. My lord, I may skip this other referring to the law. Now, may I come to the Supreme Court has referred to other judgments, and I come to my lord, page number 57, my lord, relevant para 13. Now, the background, my lord, which we have considered, the extension order was passed during the currency of the extension, that case, in Ajay Kumar case. So his challenge was turned down by the GATT. GATT did not set aside the extension order. High Court also did not, but High Court made it very clear that if you want to proceed, you proceed and conclude it within time frame. The only grievances of the central government is that whether to extend the suspension order or not. It is the prerogative of the executive. So that cannot be taken away by the court. Now, the issue is, my lord, the person is placed under suspension. Charge memo is not served. Memorandum of charge is not served to him within 90 days. The question is, my lord, if the department did not serve a charge memo within 90 days, whether his suspension order become invalid or not, illegal or not. The 90 days derived from the, my lord, the CRPC, it will come later, my lord. Now, this, the Honorable Apex Court, para 13, Lordship, allow me. It will be useful to recall that prior to 1973, an accused could be detained for continuous and successive period of 15 days, albeit after judicial scrutiny and supervision. The CRPC 1973 contains a new proviso which has the effect of circumscribing the power of the magistrate to authorize detention of an accused beyond period of 90 days, where the investigation relates to an offence punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years, and beyond a period of 60 days, where the investigation relates to any offence. The drawing support from the observations contained of the division bench in the Sansan case, 1984, and more so of the constitutional bench in Antuli, we are spurred to extrapolate the quintessence of the proviso of subsections such as CRPC to moderate suspension orders in cases of departmental disciplinary inquiries also. It seems to us, it's important, my lord, it seems to us that if Parliament consider it necessary that a person be released from incarceration after expiry of 90 days, even though an accused of commission of most heinous crimes, a forgery suspension should not be continued after the expiry of the similar period, especially when a memorandum of charge sheet has not been served on the suspended person. It is true that the proviso to such possibly personal freedom, but respect and preservation of human dignity as well as the right to a speedy trial should not be placed on the same pedestal. Now, my lord, if I understand properly this paragraph, The criminal law says that when the parliament thinks fit that accused is arrested for heinous crime, and if charge sheet is not served within 90 days, he can be released. Therefore, the Apex Court say that in a departmental proceedings also, though it doesn't relate to personal freedom, but it relates to personal dignity. Therefore, a suspended employee cannot be deprived of his right to dignity indefinitely through the suspension order. Therefore, the principle of 90 days comes into picture in this matter. Therefore, my paragraph 14, we therefore direct that the currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee. If the memorandum of charge sheet is served, a reasoned order must be passed for the extension of the suspension. As in the case in hand, the government is free to transfer the concerned person to any department in any of its office within or outside the state so as to save any local or personal contact that he may have and which he may misuse for obstructing the investigation against him. The government may also prohibit him from contacting any person or handling records and documents till at the stage of his having to prepare his defense. We think this will adequately safeguard the universally recognized principle of human dignity and the right to a speedy trial, and also have to preserve the interests of the government in the prosecution. We recognize that the previous constitution benches have been reluctant to quash proceeding on the ground of delay and to set time limits to their duration. However, the imposition of a limit on the period of suspension has not been discussed in earlier case law and would not be contrary to the interests of justice. Furthermore, the direction of the CVC that pending a criminal investigation, departmental proceedings are to be held in abeyance stands superseded in view of the stand adopted by us. Therefore, paragraph 14, if I understand properly, if the charge memo is not served to the petitioner within 90 days, that his suspension order goes. But if the charge memo is served upon me by the disciplinary authority or inquiry officer, disciplinary proceedings within 90 days, then they have the power to extend the suspension order. Yes, and they can proceed for in disciplinary proceeding. In my case, my lord, no extension, order pass, no charge memo served to the petitioner. And the affidavit filed by the state also, they do not dispute this. It's admitted position. Now, this is the law laid down, my lord. According to me, my lord, Supreme Court is very clear that within 90 days, the department has to serve charge memo. If you serve a charge memo, then you can proceed for inquiry. If you don't serve a charge memo, suspension order cannot be continued, my lord. It becomes illegal. Now, my lord, paragraph 15, the last part, but the paragraph 14, the last part, even the CVC, direction of the guidelines of the CVC that during the pendency of criminal investigation, department should not conduct the departmental proceeding. That is nullified by the Supreme Court here, that you cannot. CVC guidelines are another, any criminal angle cases are there, they can proceed simultaneously. But you cannot place the employee under suspension. Because, my lord, my lord, if I understand properly, the law is that, my lord, criminal case will take years, 10 years, 15, 20 years. If a person is allowed to be placed suspension merely because of criminal pendency, my lord, throughout his career, he'll never come back to the service. Serious impact would be there upon the employees. Therefore, since the department has the authority to suspend or terminate, dismiss the employees after inquiry, you cannot withhold that power. That's what Apex Court says. You cannot withhold that power. You can exercise, let the criminal trial court also continue. My lord, if the departmental proceedings turn out to be, my lord, without any basis, person will be reinstated in service. And subsequently, after 10 years or 5 years of the criminal trial, if the criminal court convicted me, that may be the ground for me to take up another proceeding and remove me from service. Department has that liberty. Therefore, the Apex Court is very clear that 90 days, serious criminal cases also, Parliament has given 90 days only, then why not that principle should not be applied to the employees who is receiving suspension order? So 90 days is, my lord, is a cut off date. Now, paragraph 15, so far as the facts of the present case are concerned, the appellant has now been served with a charge sheet, my lord, Therefore, this direction may not be relevant to him any longer. But by the time Supreme Court delivered this judgment in 2015, he already received a charge memo. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action of the respondent will be subject to judicial review. Therefore, my lord, since he received the charge memo during the pendency of the continued suspension order, now he may challenge the validity of the suspension order. So the time frame of 90 days will not apply to him. That is the law. But generally, my Supreme Court laid down that 90 days is applicable to disciplinary proceedings, suspended employees, as much as it applies to the criminal cases. Now, this is the judgment. Now, pursuant to this, my lord, reference to this, page number 61, this Honorable Court has also applied that principle of law, Apex Court. And by order 28.5, 2019, my lord, here also a person was placed suspension indefinitely beyond 3 months. And thereafter, my lord, this Honorable Court has interfered. And I'll just take up the operative portion. My lord, may come to page number 69. Madam. Para 17.
Yes.
Madam, by the same judgment, it is postulated that the suspension order should not extend beyond the 3 months, subject to other conditions such as filing of charge sheet, etc. And if the charge sheet has been filed, a reasoned order must be passed to justify the extension of the suspension. As such, pendency of criminal trial will not automatically render a person ineligible to reinstatement in service. With regard to the departmental proceeding, notwithstanding the duration that he has been kept under suspension, the inquiry as conducted and report as submitted, though not under challenge, cannot come within the meaning or within the four corners of duly conducted department proceeding. Though the inquiry as observed cannot be termed to be an inquiry as per law, the only fact that remains is that an exercise had been conducted, and as such it was incumbent upon the respondent to take a call on the same and review the suspension of the petitioner, my lord. Now, however, without going to the other aspects, this court, by confining itself to the impugned order and taking into consideration the subsequent development that has culminated in the inquiry report, finds that the life of the impugned order under challenge expired with the submission of the inquiry report. As such, the petitioner is entitled to consider for reinstatement into service, notwithstanding the pendency and the stage of criminal proceedings. Accordingly, it is directed that respondents are to immediately consider reinstatement of the petitioner also into service, inasmuch as the life of the impugned order has since expired. The entire exercise to be completed within a period of 8 weeks from the date of receipt of the copy of this order. However, this direction is being passed without restraining the respondent from taking further action in accordance with law. This also relied on the Archival case. Now, the state respondent has raised the, relying on the Madras High Court decision, madam. Now, in that case, earlier, the copy has been submitted by the learned AHA in the record, madam. 2022 SSC online. That is in the record.
Yes.
Good. My lord, with great respect, my lord, this decision rendered by the Madras High Court. My lord, the Madras High Court, my lord, failed to understand the, my lord, the principle laid down by the Apex Court in the Ajay Kumar case. Because they held that the Ajay Kumar case, Supreme Court did not lay down a good law. It is not applied to all the cases. That is what the Madras High Court held. And they have referred to the Ajay Kumar case. And my lord, I will take to that. This also involves suspension order, my lord. Now, my lord, we come to paragraph 14 of that judgment. And they refer, my lord, they refer to Constitution bench of the Supreme Court. I'll come to that also.
Para 14.
My lord, the reason why the Madras High Court say that Ajay Kumar case is not a good law. But para 13 may I start, my lord.
Yes.
The rules have been quoted for the reason that the judgments of different high courts and the Supreme Court have been rendered based on separate set of rules, which are not similar or parameteria to the rules quoted above. A central government servant is governed by a separate set of rules, and accordingly, the matter has to be considered in the light of the rules applicable to them. The opposite observation has been made looking to the fact that the judgments of the High Courts and Supreme Court have to be applied after taking note of the facts of the case and not by taking as to a statute. Before addressing the issue about the applicability of the ratio propounded by the Supreme Court, it would be relevant to refer the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary Supra. The judgment opposite has been heavily relied upon by the learned counsel for the petitioners. Before referring to the relevant paragraphs of the judgment aforesaid, as relied upon by the learned counsel for the petitioners, it would be relevant to narrate the facts of the said case. The delinquent officer prepared a note that approximately 4 acres of land were not defense land, but were private lands in respect of which NOCs could be issued. Based on the note aforesaid, NOCs were issued by the appellant, followed by his transfer. The NOCs granted by the appellant resulted in the action against him, and he was thus placed under suspension from such. Challenge to the order of the suspension beyond the period of 80 days was made. The challenge could not sustain, and ultimately the matter went to Supreme Court. When the matter reached the Apex Court in the year 2015, a period of 4 years had already elapsed, and in between, the charge sheet in the criminal case also submitted. In view of the above, the Apex Court refused to cause interference in the order of suspension, with the observation that whatever finding has been recorded may not be relevant to the appellant herein. However, it was observed that if the appellant is so advised, he may challenge the continued suspension in any manner known to him. The relevant paragraph heavily relied upon by the learned counsel for the petitioners in paragraph 21 of the offset judgment. However, it is to be considered in the light of the facts given above. Paragraph such is quoted herein below. We therefore direct the currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee. If the memorandum of charge sheet is served, a reasoned order must be passed for the extension of the suspension. As in the case in hand, the government is free to transfer the person concerned to any department in any of its offices within or outside the state so as to sever any local personal contact that he may have and which he may misuse for obstructing the investigation against him. The government may also prohibit him from contacting any person or handling records and documents till the stage of his having to prepare his defense. We think this will adequately safeguard the universally recognized principle of human dignity and the right to a speedy trial, and shall have also to preserve the interests of the government in the prosecution. We recognize that previous constitution benches have been reluctant to quash proceedings on the grounds of delay and to set time limit to their duration. However, the imposition of a limit on the period of suspension has not been discussed in earlier case law, and it would not be contrary to the interests of the to the interest of the justice. Furthermore, the direction of the Central Vigilance Commission that pending a criminal investigation department proceedings are to be held in abeyance stands superseded in view of the stand adopted by us. So far as the facts of the present case are concerned, the appellant has now been served with a charge sheet, and therefore this direction may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continued suspension order in any manner known to law, and this action the respondent will be subject to the judicial review. They have quoted, my lord. Now, in para 21 of the judgment Ajay Kumar Supra quoted above, rules that currency of the suspension order should not extend beyond 3 months if within that period memorandum of charge sheet is not served on the delinquent officer, and even if it is served, the reasoned order must be passed for extension of the suspension. In the next paragraph, that is paragraph 22, it was ruled that looking to the facts of the case, appellant having been served with a charge sheet, although much beyond the period of 3 months, the direction given in paragraph 21 were held to be not irrelevant. Yet, ignoring the direction given in the paragraph 22, the judgment in the case of Ajay Kumar Supra is applied even to the cases where the charge sheet is served before the challenge of the order of the suspension or during the pendency of the revision, though service of charge sheet may be after a period of 3 months. Therefore, it is only one aspect to find out the extent of applicability of the case of Ajay Kumar Supra. Otherwise, the judgment render therein is driven by sections of the CRPC 1973, which provides the period for submission of the charge sheet. But it is only for the purpose of period of remand and does not provide the limitation for submission of charge sheets in general. The charge sheet in the criminal case can be filed even beyond the period given under CRPC 1973. But in case of arrest of the accused and remand in jail during the period of investigation, the remand cannot be extended beyond the period of 90 days or 60 days in given case. And in case the charge sheet is not filed within the period aforesaid, the accused will be entitled to statutory bail. The fact aforesaid has been explained in reference to sections CRPC because the Apex Court in the case of Ajay Kumar Supra has drawn the analogy of 3 months from the provision aforesaid and would be reflected from the perusal of the para 20 of the judgment, which is quoted hereinda for ready reference. It would be useful to recall that prior to 1973, an accused could be detained for a continuous and consecutive period of 15 days, albeit after judicial scrutiny and supervision. The CRPC 73 contains a new proviso which has the effect of circumscribing the power of the magistrate to authorize detention of an accused person beyond a period of 90 days where investigation relates to an offence punishable with death, imprisonment for life, or imprisonment for a term of no less than 10 years, and beyond a period of 60 days where the investigation relates to any offence. Drawing support from the observations contained of the division bench in case 1986, and more so of the Constitution bench in Antule Sansaj, we are spurred to extrapolate the conditions of the proviso to Sansaj to moderate suspension orders in cases of departmental or disciplinary proceeding. It seems to us that if the Parliament considers it necessary that person must be released from the incarceration after a period of 90 days, even though accused of commission of most heinous crimes, a fortiori suspension should not be continued after the expiry of similar period, especially when a memorandum of charges or charge sheet has not been served on the suspended person. It is true that the proviso to postulate personal freedom, but respect and preservation of the human dignity as well as the right to a speedy trial should also be placed on the same pedestal. It needs to be clarified that the provision of the CRPC would have no application to service jurisprudence. My Lord, this is contrary to the Apex Court order. Now, where the Madras High Court is traveling beyond the Apex Court judgment, my Lord. Apex Court say that the principles of 90 days principle in criminal case is applicable to the suspension matter. Now, Madras Court say no, it is not applicable. Now, accordingly, the judgment of the Apex Court and Ajay Kumar Supra needs to be considered for its application. In such context, the division bench of this court in Sansaj held that the law laid down by the Apex Court in the case of Ajay Kumar Supra does not lay down any absolute proposition that order of suspension can never be extended beyond 3 months. Paragraph delivered by the division bench of Sansaj. They have quoted their own Madras High Court judgment. Now may I come to my Lord, para 20, the next page. A few paragraphs, my Lord. Para 20, my Lord. Subsequent to the judgment of the aforesaid, a challenge to prolonged suspension was considered by the division bench in the case of Sansaj Tamil Nadu Generation Sansaj 2020 passed in WA number Sansaj, wherein referring to the earlier judgment of a division bench of this court in the case of Sansaj and the judgment of the Delhi High Court in the case of Sansaj 2017 online, it was held that in cases relating to order of suspension involving grave charges leading to criminal trial, interference with the suspension order on the basis that the suspension period exceeded 3 months is not justiciable. But it is grave charges there. The fact of the case in those cases are grave cases. Here, present case is not matter. Another judgment of the division bench of this court in the case of secondary Sansaj 19, wherein referring to several judgments of the Apex Supreme Court in paragraph Sansaj, interference with the order of suspension was not made. Though wherein the judgment of the Apex Court in the case of Ajay Kumar Supra was not referred. However, the division bench was considered the issue in reference to the judgment of the 5 judges bench of the Apex Court in the case of Sansaj IR 1964. The judgment in the case of Kapoor supra rendered by the 5 judges of the Supreme Court was not cited by the counsel who appeared in the case of Ajay Kumar Chaudhary. Now, I will take, my lord, 1964. It has no relation with the time limit, though involve a suspension order, application of the law in that 1964. But the Madras High Court, early division bench, and that present division bench is relying that the Supreme Court has passed an order in 1964. I'll come to that one. Now, in view of this, my lord, the Madras High Court, my lord, para 25, Lordship kindly come to para 25.
23, no?
But 25.
23,
Which part?
Paragraph 23.
Paragraph 23. That 23 was weekend. Because I have that citation. Para 23, my lord. R.K. Kapoor Supra, the Constitution Bench held. Another argument that is urged on behalf of the respondent is the suspension pending a department inquiry or pending criminal proceeding cannot be said to be a disciplinary matter at all, and therefore the protection of Article 314 does not extend to such suspension. We cannot accept this argument. The words disciplinary matters with which we are concerned appear in a constitutional provision and must be given their widest meaning consistent with what disciplinary matters may reasonably include. Suspension is of two kinds, namely as a punishment or as an interim measure pending in a department inquiry or pending a criminal proceedings. We shall deal with these aspects of suspension in detail later. So far as suspension as a punishment is concerned, it is considered that it is a disciplinary matter. The dispute is only as to suspension pending a department inquiry or pending a criminal proceeding. There can be, in our opinion, no doubt that suspension of this kind also must be comprised within the words disciplinary matter, as used in Article 314. Take the case of suspension pending a department inquiry. The purpose of such suspension is generally to facilitate a department inquiry and to ensure that while such inquiry is going on, it may relate to serious lapses on the part of the public servant. He might have been charged to have done so in the inquiry. In such a case, suspension pending a department inquiry cannot be but a method immediately related to disciplinary matters. Take again the case where the suspension is pending criminal proceedings. The usual ground for suspension pending a criminal inquiry proceeding is that the charge is connected with his position as a government servant or is likely to embarrass him in the discharge of his duties or involves moral turpitude. In such a case, a public servant may be suspended pending investigation, inquiry, or trial relating to criminal charge. Such a suspension also, in our opinion, is clearly related to disciplinary matters. If the trial are follow against the public servant so convicted, even in case of acquittal, proceedings may follow where the acquittal is other than the honorable. The usual practice is that where a public servant is being tried on a criminal charge, the government postpones holding departmental inquiry and awaits the result of the criminal trial, and departmental proceedings follow on the result of the criminal trial. Therefore, suspension during investigation, inquiry, or trial relating to criminal charge is also, in our opinion, intimately related to disciplinary matters. We cannot therefore accept the argument on behalf of the respondent that suspension pending a departmental inquiry or pending investigation or inquiry or trial relating to criminal charge is not a disciplinary matter within the meaning of Article 7. My lord, I'll come to that judgment, my lord. The issue involved in that case, 1964, is, my lord, whether a person facing a criminal trial, my lord, and place him under suspension, whether that action will fall within the ambit of disciplinary matters or not. Supreme Court says that it falls within the meaning of disciplinary matter. Supreme Court never decides that person can be placed under suspension beyond 90 days without serving charge, without serving a charge memo. That was not the issue. That was not the issue. Now, admittedly, in Ajay Kumar, it says, Supra, the two judges of bench did not consider the earlier constitution judgments. But para 24, madam. Admittedly, in Ajay Kumar, Supra, the two judges bench, that is Ajay Kumar, did not consider the earlier constitution bench judgments on the issue of suspension. Quote the binding precedents of the law laid down by the bench of larger strength. A constitution bench of the apex court in Central Court of Sunset held as under. That's an undisputed one. The larger bench pronounced judgment it will prevail over the smaller bench. Well, now I come to para 25, the next page. Inasmuch as the Apex Court in Ajay Kumar Chaudhary Supra has not considered the earlier judgments of the constitution benches of the Apex Court, the earlier judgment delivered by bench of larger strength would be binding on high courts too, and it cannot be said that the judgment in Ajay Kumar Supra lays down absolute proposition of law on suspension, as what was held in paragraph 21 of the judgment was not applied in the case itself in paragraph 22. It is despite the fact that charge sheet therein was submitted much beyond the period of 3 months. Much beyond the period. Learned counsel for the petitioner referred to the judgment in the case of judgment, ignoring the set of rules applicable therein, and otherwise the judgment therein has not laid down absolute proposition of law. In no case, the order of suspension can continue beyond a period of 3 months if memorandum charge sheet is not served to the delinquent within a period of 3 months. Rather, it was not applied in the case itself. Now, Ajay Kumar case is very clear, my lord. Suspension was the suspension 190 days at one go, and before 180 days over, they issued a extension order one after another. In that process, within 4 years, charge sheet was filed. Therefore, Apex Court said that since you received the charge sheets, this law will not applicable. But this would be the general law, 90 days. Now, in my case, my lord, in my case, within 90 days, neither charge sheet was served by the trial court also, nor the charge memo was served. And the respondent is not denying the affidavit. In the affidavit. Now, the Madras High Court say that it refers to, my lord, it refers to Constitution bench and heavily relied on the 1964 judgments. Now, before, my lord, I take to the Apex Court judgment 1964, my lord may kindly see para 31 of the same judgment, Madras High Court.
Yes.
My lord, I just read out 31. At this stage, we need to refer to the judgment of Apex Court in the case of such Supra. Therefore, such judgment is again to be read in the context of the facts given. That was the case of deemed suspension, as the employee here remained behind bars for more than 48 hours, wherein largely the issue was in reference to the challenge to the charge memo. In paragraph sentence of the said judgment, the court analyzing the facts did not find it appropriate to continue the order of suspension, as there could be no threat to the fair trial. The judgment in the case was on its own facts. Thus, we are of the considered view that the judgment of the Apex Court in the case of Ajay Kumar Supra does not lay down absolute proposition of law. Then an order of suspension cannot be continued beyond a period of 3 months if the memorandum charge sheet is not served within 3 months. Rather, the issue of challenge to the order of suspension should be analyzed on the facts of each case. It is keeping with the gravity of the charges and the period therein against the case in track. The order of the interference with order of suspension have been has serious consequences, my lord. So the Madras High Court completely ignored the my lord, the Ajay Kumar case, and say that it depends on the fact of the cases. Now, since the Madras High Court referred to the 1964, let us see the fact of the case, the Supreme Court in 1964. The issue involved, my lord. I've cited, my lord. EIR 1964, my lord. SC 787. My lord, the brief background, my lord, here.
Yes.
The petitioner in this case before the Supreme Court, he was a secretary before in the princely state, before the independence, my lord. And after independence, my lord, he was conferred the IS cadet. And the power under the rules, central government has the power to place him under suspension, take action. Now governor has placed him under suspension, governor of a state. Now the issue arose, my lord, he challenged the rules also. And he said that I'm not governed by the rules, by the new rules. Now the issue, Lordship, I'll take straight away to para 3, page number, my lord, 789, para 3, my lord.
Yes.
My lord, it says, on July 18, 1959, the appellant was suspended with immediate effect by the governor of Punjab on the ground that a criminal case was pending against him. The order also provided that for the period of suspension, the appellant shall be paid subsistence allowance, which shall be equal to leave salary, which he would have drawn under the leave rules applicable to him if he had been on leave on half average pay, with a further provision that in case the suspension lasted for more than 12 months, a further order fixing the rate of subsistence allowance shall be passed. This order appears to have been passed under Sansad discipline rules, and in consequence thereof, the appellant remained under suspension. The appellant filed a writ petition in the Punjab High Court on Sansad 62, challenging this order of suspension. His contention was that he was entitled to guarantee under Article 314 of the Constitution, and the order of suspension passed against him violated that guarantee and was therefore ineffective and invalid. He relied for this purpose on rules and such of the appeal rules, which provided for suspension as a penalty. He contended that the appeal rules which govern him and which must be held to have continued to govern him in view of the guarantee contained in Article 314 provided for suspension as a penalty only, and that there was no provision anywhere in any rule or statute immediately before January 1950, on which the date the Constitution came into force, providing for suspension otherwise than as penalty. Therefore, it was not open to the governor to suspend him in the manner in which he did so in the present case, though it was not denied that he would be suspended pending criminal proceedings, provided the suspension as a penalty under Rule 49 of the appeal rules. On the other hand, mere suspension pending criminal case was not inflicted as a penalty was not provided at all by the rules on the statute governing the appellant immediately before January 1950. Therefore, when the governor proceeded to suspend him under such, he violated the guarantee under Article 314. The appellant also contends that as it was not open to any authority to suspend him except as a punishment immediately before the 1950, rules and such rules which provide for suspension during disciplinary proceedings or during the pendency of a criminal proceeding, so far as it applies to him, was authorized to Article 314 of the Constitution. He also attacked to rule number such, validative articles such, being concerned with the penalties to be imposed on the members of the Indian Administrative Service and rules and such. May I come to Para 7, my lord? The only issue seized by the Apex Court in that case.
Yes.
Para 7, my lord. The only question that has been debated before us is with respect to suspension, whether as a punishment or as otherwise, of a member of one of the Secretary of the State Services. In this case, the Indian Civil Service, members of which have become members of the Indian Administrative Service under the recruitment rules. And it is only this question that falls to be determined in the present appeal. But the appellant has also challenged Rule 3 and 10 of the appeal rule, disciplinary rules, which do not deal with the suspension at all. In these circumstances, we do not propose to consider the vires of the rules 3 and 10, for that does not fall for decision as the order which is challenged has not been made under Rule 3 and relates only to suspension. It is therefore unnecessary to decide whether Rule 3 and 10 in the challenged circumstances apply to those members of the Indian Administrative Service who were at one time members of the Indian Civil Service. We shall therefore express no view one way or the other on the vires of Rule 3 and 10, and consider only Rule 7, which deals with suspension. We shall also like to make it clear that what we say during the course of this judgment with respect to suspension refers only to those members of the Indian Administrative Service who became members thereof under Sansad recruitment rules, and not to other members of the Indian Administrative Service who were not members under 1949 of the Indian Civil Service. For it's only the former kind of members of the Indian Administrative Service who are entitled to the protection of Article 314, and the whole case of the appellant is based on that protection. Now, my lord, the para may come to 25, my lord. With Article 301, there is a protection for those employees who serve prior to the independence. Now, para 25 may come of that judgment, my lord. Running page would be 798.
Yes.
Part 25, my lord. This brings us to the question of relief to be granted to the appellant. It appears that on September 1963, the governor passed an order by which he reinstated the appellant for the period from July to July 1963 and granted him his full emoluments for that period. The writ petition in the present case was filed in 1962. So the appellant is apparently not entitled any further relief in the matter of his emoluments beside what has been granted to him by the governor. The order of reinstatement contained therein is unnecessary in view of our decision, and the order granted full emoluments may be taken to be in pursuance of our judgment. We therefore allow the appeal and declare Rule 7 of the discipline rules insofar as it applies to members of the Indian Administrative Service who are members thereof by virtue of Rule 3A and B of the recruitment rules to be bad to the extent to which it permits an authority other than the government of India to suspend an interim measure, not as a punishment, with such members of the services. In consequence, we set aside the order of the governor, such as, however, the order 1963 has granted all such monetary reliefs to the appellant as we could grant him on setting aside the order of the 1959. No further relief can be granted to the appellant. We therefore we order the respondent, the state of Punjab, to pay the cost of appellant in this court as well as the High Court matter. So Supreme Court upheld the interfer with the order, but during dependency he was reinstated. Therefore, once he is reinstated with all the emoluments, the petitioner was not entitled for the reliefs, appellants. That was the decision. Now, in that case, my lord, the principle of application of 90 days was not at all the issue. Whereas Ajay Kumar case, that is the issue. Whether, my lord, placing a suspension a person and allow him to continue beyond 9 days without serving a charge memo, without charge sheets, is permissible or not. So Apex Court said it is impermissible. The principle of CRPC is applicable to suspension, my lord. Therefore, the Madras High Court is, my lord, completely misunderstood the content of the principle laid down by the Apex Court. Now, what happened during dependency in this case, I will conclude. Realizing this issue, the government has passed the extension order.
Was this conflict resolved?
Madam.
Was this conflict resolved at any point of time in some other case?
No, my lord.
Conflict between the Madras High Court and the Ajay Kumar case?
No, my lord, so far as my research is concerned, I do not come across any of the Supreme Court order regarding this Madras High Court order. And Madras High Court order is not standing on its own foot, standing on the law laid down by the Apex Court 1964. I don't come across other constitution benches. It refer. I don't come across any constitution benches rendered by Supreme Court laying down this principle, apart from 1964. And 64 is not at all involving the imposition of limits, 90 days limit. Now the suspension, during dependency, they have, my lord, the respondent has extend the suspension order. My lord, may kindly, it must be there earlier, my lord, the AG has submitted the suspension order dated 23rd August 2022. My lord, in May.
Order?
One page, my lord, 29.
There is an additional affidavit to that effect, your lordship. That was filed on 19 to 24. 29 to 24.
Yes, my lord. Para 5. Lordship, can you see? 29 August.
Extended.
My lord. Now it says, in exercise of the power under rules and such, 2011, in continuance with the suspension order 2017, the suspension in respect of Such, a school following his arrest in connection with his Such, IPC is hereby extended until the conclusion of the criminal proceeding against him. My lord. Now, may I just refer to the disciplinary appeal rules. I have submitted the copy. It must be there, my lord. AP Rules 2011. Lordship, got it. My Lord, Section 6, Rule 6, may I refer to Rule 6. Under Rule 6,
suspension.
Yes, they can place me under suspension. Now, to save Lordship time, may I state, we go to, my Lord, Sub-Rule 5 and 6, Sub-Rule 5A and B, the next page, on the top.
Yes.
My Lord. An order of suspension made or deemed to have been made under this rule shall continue to remain in force until it is modified or revoked by the authority competent to do so. So they have the power to revoke or modify. The power is vested with them. I have no dispute. Now they have invoked this P, where a government servant is suspended or is deemed to have been suspended, whether in connection with any disciplinary proceedings or otherwise, and any other disciplinary proceedings is commenced against him. Well, there is no commencement of the inquiries against him. During the continuance of that suspension, the authority competent to place him under suspension may, for reasons to be recorded in writing, direct that the government servant shall continue to be under suspension until termination of all or any such proceedings. Provided an order of suspension made or deemed to have been made under this rule may at any time be modified or revoked by the authority which made or is deemed to have been made the order, or by any authority to which that authority is subordinate. They have the power, my Lord. I have no dispute. They have the power to modify it or review. Yes. The only issue is, my Lord, without...
It says they have the power to modify or revoke.
Yes.
But as far as suspension is, extension is concerned, it's a different
issue. Now, the rule do not specify that the life of the suspension order. But it says that the department has the authority to extend it. Now, this rule has to be read with the law later by the Apex Court.
So you mean as far as the time limit is concerned?
Time limit is concerned. 90 days is concerned. They have to, under Article 142, the Apex Court order definitely bind to the government, despite of the rule in place here. And rule do not provide the life of the suspension order. Now, when we read together, my Lord, this rule 6 AP, 5 AP should be read with the Apex Court order. And when we read this with Apex Court order, it is very clear that within 90 days, they have to serve me a charge memo. And within that, they can pass an extension order by invoking power under Rule 6, 5 A and B. Now, without serving a charge memo, without serving a charge sheets, my Lord, they cannot extend. That is what the Apex Court says. They cannot extend. Now, they have extension order was passed 2022. He was placed under suspension 2017. After 4 years, they passed extension order. Now, relating to this, my Lord, I'll cite one judgment. What is the law on this? Where, my Lord, the order was passed after expiry of the time. What is the effect of that order? I have just, I'll place one order. This extension order is after thought, my Lord. If this is permissible, my Lord, no citizen would be able to make out the case. When the citizen comes before this court, government will correct all its mistakes, improve in the file,
yes,
my Lord, and submit it before this court. Citizen will never get relief, my Lord. My Lord, the Apex Court, my Lord, there's one judgment. This relates to suspension order.
yes.
And it, in the rules, it prescribes the 90 days also. And if the order, suspension order passed before or beyond 90 days, what is the effect? No extra paper. My Lord, may come to para 10. My Lord, to save Lordship time, para 11, my Lord, since I've given copy to
This one.
my Lord, page number 8. May start from para 10, my Lord, better to complete.
Para 10 or 11?
My Lord.
From para 10 or 11?
Para 10, my Lord. Para 10 and 11, my Lord.
Yes. Yes.
Mary, my lord. Having carefully considered the submissions made on behalf of the parties, and having also considered the relevant dates relating to suspension of the respondent, and when the petitioner's case came up for review on 20 October 04, we are inclined to agree with the views expressed by the Central Administrative Tribunal, as confirmed by the High Court, that having regard to the amended provisions of sub Rule 6 and 7 of Rule 10, the review for modification or revocation of the order of suspension was required to be done before the expiry of 90 days from the date of order of the suspension. And as categorically provided under Sub-Rule 7, the order of suspension made or deemed would not be valid after a period of 90 days unless it was extended after review for further period of 90 days. The case sought to be made out on behalf of the petitioner, Union of India, as the cause of delay in reviewing the respondent case is not very convincing. Section such of the Administrative Tribunal Act speaks of abatement of proceedings once an original application under the said act was admitted. In this case, what is important is that by operation of Sub-Rule 6 of Rule 10 of the 1965 rules, the order of suspension would not survive after the period of 90 days unless it was extended after review. Since admittedly the review had not been conducted within 90 days from the date of suspension, it became invalid after 90 days. Since neither was there any review nor extension within the said period of 90 days. Subsequent review and extension, in our view, would not survive the order which had already become invalid after the expiry of 90 days from the date of suspension. Therefore, my submission is, my lord, when we read Ajay Kumar case laying down 90 days, the moment 90 days is over, whatever subsequent extension order passed by the government here, 2022, will not validate. Because the earlier suspension order already stands expired. 90 days from the date of suspension, 15 September 2017. So therefore, the respondent cannot restructure his case to resist the petition. So this is my humble submission. The law is very clear. So Lordship may interfere with the suspension order, and he's still young to perform his duty. And the nature of the case, my lord, the girl involved, the complainant, is no longer a student there. Well, there is no question of interfering with her or interfering with the criminal case. Criminal case, my lord, POCSO matter, he's facing trial, my lord, consistently, my lord. So my humble submission, Lordship, in view of this Ajay Kumar case, Lordship may kindly consider my prayer.
May it please your lordship. Lordship, I am taking lordship to page 32 to the writ petition, your lordship. Page 32 to the writ petition. The contention that there was no charge memo or statement of allocation had been issued, that is factually incorrect, your lordship. Lordship, kindly come to page 32 and 6 to the writ petition.
Yes.
This is discharge memo, your lordship. Lordship,
show cause notice.
Lordship, no statement. No, this is charge sheet, charge memo only. Your lordship, kindly come to the next page. Statement of allocation, your lordship.
Okay.
Lordship. So keeping in view, your lordship, that since the criminal investigation and the criminal trial is going on, your lordship, so the department in its wisdom thought it fit that the departmental inquiry against the petitioner be kept in abeyance till the conclusion of the criminal proceeding, your lordship. This is what the department has done, your lordship. And It is not a case, Your Lordship, that no charge sheet has been filed, no statement of allegation, no charge may have been issued against him. That is not wrong. This is the charge sheet against him, Your Lordship. This is the charge sheet, Your Lordship. Can you see, Your Lordship, who is he? The petitioner is a teacher, Your Lordship. That too in a government girl high school. He is supposed, Your Lordship, to try to protect, Your Lordship. Rather, he became invasive, Your Lordship. And you see, Lordship, the gravity of the situation, the gravity of the alleged misconduct, Your Lordship, the gravity of the Lordship. A young girl, Your Lordship. He is supposed, Your Lordship, to guide, to teach, right, Lordship. Can you see, Your Lordship, the gravity, the seriousness, Your Lordship, whether Your Lordship will allow the writ petitioner to resume, Your Lordship, his duty as a teacher, Lordship, and that too in an institution where most only girls are studying, Your Lordship. In my humble and respectful submission, Your Lordship, the continuance of the suspension, Your Lordship, has been done by the government, keeping in view, Your Lordship, the seriousness of the allegation and also the fact that the criminal trial is going on. And Lordship, by 26/11 we'll know the fate of the writ petitioner, whether he will be acquitted or whether he will be convicted, Your Lordship. The matter is fixed on 26/11/2024, Your Lordship, before the trial court for final argument, Your Lordship. For final argument, Your Lordship.
Judgment will take some time then.
Lordship, I don't think the judgment will take some time, Your Lordship. I don't think, Your Lordship, it will take at least 2 weeks' time, Your Lordship. Lordship, my argument first is, Lordship, that the judgment laid down by the Apex Court in Ajay Kumar, Lordship, will not be applicable in this case, Your Lordship, because here in the case, Your Lordship, there is no time limit, Your Lordship. So there is no time limit. In the rules, Your Lordship, in the Meghalaya Service Discipline Appeal Rule 2011, there is no such time limit, Your Lordship.
Rules?
There is no such time limit, Your Lordship. If Lordship kindly come to Rule 6 of that Rule 2011. If Lordship kindly come to 6.2.
Yes, ma'am.
A government servant who is detained, Lordship.
Six two,
Your Lordship, yes. 6.2. May I read it, Your Lordship? May I read it, Your Lordship? A government servant who is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours, shall be deemed to have been suspended with effect from the date of such detention by an order of the appointing authority, and shall remain under suspension until further orders. Until further orders, Your Lordship. Then, Your Lordship, the government, in exercise of the power under the same rule, Your Lordship, that is 5B. Lordship, it has been referred by my friend, where a government servant is suspended or is deemed to have been suspended, whether in connection with any discipline proceeding or otherwise. Otherwise, Your Lordship, that means criminal proceeding, Your Lordship, as earlier it has been held, referred in the judgment earlier, Your Lordship, that even a criminal proceeding also, that also is a disciplinary proceeding, Your Lordship. Or any other disciplinary proceeding is common against him during the continuance of that suspension. The authority competent to place him under may, for reason to be recorded by him in writing, direct shall continue to be under suspension until termination of all or any other proceeding. So that power is there, Your Lordship. Continue with the order of suspension, Your Lordship. That power is there, Your Lordship. With the authority, Your Lordship, keeping in view, Your Lordship, the seriousness of the allegation against the petitioner, Your Lordship. Lordship, I have relied in the case of the Madras High Court, Your Lordship. Lordship, my friend has not referred para 33. Lordship, kindly come back to the judgment of the Madras High Court. At para 33, Your Lordship. What does the Honorable Supreme Court says, Your Lordship, which has been quoted by the full bench of the Honorable Madras High Court? Lordship, I have an extra copy.
No, it's here.
Lordship, kindly come to para 33. Moreover, Your Lordship. May I read it, Your Lordship?
Yes.
Moreover, an order of suspension is not considered to be a punishment. Lordship, I have a ready copy with
No,
me.
it's here. Just looking at my notes. Yes.
Moreover, an order of suspension is not considered to be a punishment, as has been held by the Apex Court in the state of Orissa versus Bimal Kumar Mohanty. For ready reference, so and so, it is the settled law that normally when an appointing authority or the disciplining authority seeks to suspend an employee, pending inquiry or contempt inquiry or pending investigation into create charges of misconduct or defalcation of fund or serious act of omission and commission, the order of suspension would be passed after taking into consideration the gravity of the misconduct sought to be inquired into or investigated and the nature of the evidence placed before the appointing authority and on application of the mind by the disciplinary authority. Appointing authority or disciplinary authority should consider the above aspect and decide whether it is expedient to keep an employee under suspension pending aforesaid action. It would not be as an administrative routine or an automatic order to suspend an employee. It should be on consideration of the gravity of the alleged misconduct or the nature of the allegation imputed to the delinquent employee. The court or the tribunal must consider each case on its own fact, and no general law could be laid down in that behalf. Suspension is not as punishment, but only one of forbidding or disabling an employee to discharge the duty of office or post held by him. In other words, it is to refrain him to avail for the opportunity to perpetrate the alleged misconduct or to remove the impression among the members of the service that dereliction of duty would pay fruits, and the offending employee could get away even pending inquiry without any impediment, or to prevent an opportunity to the delinquent officer to scuttle the inquiry or investigation, or to win over the witnesses, or the delinquent having had the opportunity in office to impede the progress of the inquiry. But as stated earlier, each case must be considered depending on the nature of the allegation, gravity of the situation, and the indelible impact it creates on the service for the continuance of the delinquent in serving pending inquiry or contemplated inquiry or investigation. It would be, among other things, if the action is actuated by malified, arbitrary, or further, the suspension must be stepping aid to the ultimate result of the investigation or inquiry. The authority also should keep in mind public interest of the impact of the delinquent continuance in office while facing department or trial of a criminal charge. That is what, Lordship, we have done here, Lordship. We continue the order of suspension. Then, Lordship, kindly see 34. Reference to the above judgment of the Apex Court, a division bench of this court in so and so, Lordship, Lordship, that has been quoted by in that Bimal Mohanty Kumar, Lordship. In the case of Bimal, the Apex Court held that it's not a punishment, Lordship. Judicial, Lordship, somewhere in the middle, judicial review in such matters should be minimal. In the instant case, the allegation against the link is quite serious. Not only, Lordship, this is a bribe, your Lordship. Then, Lordship, kindly come 21.
Yes.
In view of the above, we find reason to cause interference with the judgment of the learned single judge, as none of the judgments cited by the learned counsel for the writ petitioner, non-appellant, provide assistance on the issue. Rather, those judgments have been given referring to the judgment in the case of Ajay Kumar Chowdhury Supra without analyzing the fact that even the case of Ajay Kumar Chowdhury, Lordship would emphasize on this, the order of suspension was not interfered with by the apex court, though the charge sheet in the said case was filed after 3 months since the date of initial suspension of delinquent. Lordship, in Ajay Kumar also, Lordship, the Honorable Supreme Court did not interfere, Your Lordship. It did not interfere with the order of suspension. So what was the decision rendered by the Madras High Court, Your Lordship? The judgment of the apex court in the case of Ajay Kumar Chowdhury Supra does not lay down absolute proportion of law that an order of suspension cannot be counted beyond the period of 3 months if the memorandum of charge has not been served within 3 months. Lordship, in this case, it has been served, Your Lordship. The DP has been kept in abeyance because there is an ongoing criminal proceeding and criminal trial. The judgment in R. Balaji Supra has no reference to the early judgment of co-equal strength and is hereby rendered per in accuriam. The issue of challenge to the order should be analyzed on the fact of each case considering the gravity of the charges and the rule applicable. The rule applicable here, Your Lordship, is Rule 2011, Your Lordship. There is no time limit, Your Lordship. Revocation of suspension with a direction to employer to post the delinquent in a non-sensitive post cannot be endorsed or directed as a matter of course. It has to be based on fact of each case, and after noting the reason for the delay in serving the amount of charges, such it that will not applicable, Your Lordship, because here. Then, Lordship, another decision I would like from the Honorable Madras High Court, Your Lordship. This is on a single bench judgment, Your Lordship. Lordship, I am taking Lordship to para 9 of that judgment. Para 9, Lordship, that has been quoted, Your Lordship, reiteration of the judgment of the Honorable Supreme Court, Your Lordship. If Lordship kindly come to the at page 19, Your Lordship, 1519, Your Lordship, towards the end, Your Lordship, towards the end, thus, Lordship is with me. Lordship, there is a 1519 down below on the left, Your Lordship.
Yes.
If Lordship kindly see, thus, the word thus, Lordship is with me. Thus.
Yes.
The judgment in the case of Ajay Kumar does not lay down the ratio that suspension order would be illegal if it is continued beyond the period of 3 months of criminal case. Rather, in the case of so-and-so itself, the order of suspension was not interfered because charge sheet was later on file, though after 3 months since the date of initial suspension of delinquent. Lordship, then Lordship kindly see para 11, Your Lordship. Para 10, on the basis even as against the petitioner in this case, already a criminal case is pending and the same has culminated in the filing of charge sheet as against the petitioner, as a result of which it is not mandatory on the part of the respondent to revoke the currency of suspension immediately, and hence the other limb of made by Land Council seeking review of this is not sustained and pursuant. Considering the fact and circumstances of the case, and keenly considering the fact that the petitioner is a teacher, Your Lordship, in this case, Your Lordship, a teacher, Your Lordship, though it is a case of bribery, Your Lordship.
I will continue.
Lordship, I'm concluding my argument on the Lordship.
I have to give some reply.
I have been.
Lordship, yes.
I have been called.
Lordship will continue after the. Will continue.
I think we'll have to be in a second.
I don't know, Your Lordship. Or we can have.
Lordship convenient anytime.
Or we can have it tomorrow also, Your Lordship.
Not tomorrow.
Or we can have after next week also, Your Lordship. After next week, in the next week, Your Lordship.
In the meantime, if you try to, file a brief written synopsis of your.
Lordship, we also will make a bullet point, Your Lordship. Lordship, yes.
So we'll see if time permits. Then, as far as your case is concerned, next week.
Next week, Your
The other
Lordship.
case.
Other matter, Your Lordship. Next matter may kindly be put next week also, Your Lordship. That Nabam.
Also, let this matter come tomorrow, Lordship, if it's possible.
We'll do next week, Your Lordship.
Or on Friday, Lordship, if it's possible. Friday.
Yes.
This Friday, Lordship.
We'll see next week.
Next week, Your Lordship.
Lordship,
Apply, Your Lordship.
to mention item 19, Lordship.
The last item.
Lordship, here I'm seeking withdrawal, Lordship. With a
Withdraw.
liberty. To withdraw with a liberty, Lordship.
So I'll pass the C orders.
In 19, Lordship. Oblige.
Should note down tomorrow. Item number 3, Lordship. Let it be tomorrow, Lordship. Next. Okay. Okay, tomorrow then.
Tomorrow.
Oblige, Lordship.
And sir, no harms for you. We can check the previous orders and see this one. There's a private respondent. We compare it also. 1 to 5 is